The congressional hearing room grew silent. Representative Jasmine Crockett stood poised at the podium, her burgundy suit sharply contrasting with the oak panel backdrop. Just moments earlier, Supreme Court Justice Amy Coney Barrett had directed precise criticism her way. Congresswoman Crockett, you be notably vocal on constitutional interpretation despite limited judicial experience. Perhaps you could outline the originalist view of the 14th Amendment, Barrett said, her voice edged with dismissal. Several Republican committee members exchanged knowing looks. The intent was obvious. With her distinguished academic credentials and Supreme Court position, Barrett appeared ready to highlight the freshman Congresswoman's supposed legal gaps on national television. But Crockett remained calm. She opened her leather portfolio and pulled out a document no one expected her to have. As she began to speak, Barrett's confident demeanor shifted to visible surprise. What unfolded over the next 4 minutes not only silenced a Supreme Court justice, it reshaped how the country would perceive both women. Before we examine this rare exchange, be sure to like this video and subscribe for more political coverage not often shown by mainstream outlets. Justice Amy Coney Barrett had long been a respected figure in conservative legal circles. A graduate of Notre Dame Law School, where she later became a highly regarded professor, Barrett clerked for the late Justice Antonin Scalia, adopting his originalist philosophy. At 51, her swift appointment to the Supreme Court in 2020 secured her place as a conservative legal icon, known for her polished presence, precise speech, and strict commitment to textualist interpretation. Barrett was a leading voice on the court. She firmly upheld originalism, the view that the Constitution must be interpreted according to its original public meaning, and often criticized what she considered activist reinterpretations. In private, Barrett reportedly voiced concern over elected officials making constitutional claims without substantial legal expertise. Representative Jasmine Crockett presented a very different profile. At 42, the Texas freshman Congresswoman was known for directly challenging conservative judicial perspectives. Her bold suits, straightforward tone, and unapologetic advocacy made her a frequent target for conservative critics, many of whom dismiss her as a progressive politician lacking serious legal depth. What often went unnoticed was Crockett's substantial legal background. Before entering politics, she had a successful career as a civil rights attorney in Texas, taking on complex constitutional cases. A graduate with honors from the University of Houston Law Center, she had argued before the Fifth Circuit Court of Appeals several times. Yet her legal credentials were frequently overshadowed by her political image, especially in conservative media portrayals. The friction between Barrett and Crockett had been building for months. It started when Crockett delivered a House floor speech criticizing recent Supreme Court rulings on voting rights and affirmative action, directly questioning Barrett's reasoning. At a Federalist Society event, Barrett later remarked, without naming Crockett, that certain elected officials misrepresented judicial reasoning for political ends. The tension deepened when Crockett published a detailed Harvard Law Review critique of Barrett's affirmative action opinion, arguing that Barrett's originalist reading ignored the historical realities of the Reconstruction Amendments. While legal scholars praise the piece, conservatives dismiss it as politically motivated. Their face-to-face confrontation became inevitable when Barrett agreed to testify before the House Judiciary Committee on Constitutional Interpretation and Judicial Philosophy. It is rare for Supreme Court justices to appear before Congress, but Barrett accepted the Republican chair's invitation. Seeing it as a chance to publicly defend originalism, conservative outlets promoted the hearing as an opportunity for Barrett to educate progressive lawmakers. Many specifically singled out Crockett, predicting she would be outmatched by Barrett's legal expertise. What they didn't know was that Crockett had spent weeks preparing, consulting top constitutional scholars with expertise in Reconstruction-era history, and compiling a detailed analysis of inconsistencies in recent originalist decisions. The Judiciary Committee hearing was packed. Journalists lined the walls, cameras ready to capture every exchange. Lawmakers from both parties arrived early, eager for front-row seats. The formal wood paneling and historic portrait in the room gave the setting an added sense of gravity. Justice Barrett sat alone at the witness table, a glass of water untouched beside her. Dressed in a conservative navy suit with her hair neatly pulled back, she projected composed authority. After the opening remarks and initial questioning from senior members, the chair recognized Representative Crockett for her 5-minute session. Crockett approached the podium with deliberate confidence, set her portfolio down, and adjusted the microphone. "Thank you, Justice Barrett, for joining us today," Crockett began in a measured tone. I'd like to focus on your approach to constitutional interpretation, particularly regarding the Reconstruction Amendments. Barrett gave a slight nod, her expression steady. Before my first question, Crockett continued, I want to confirm that we both agree the Constitution should be interpreted according to its original public meaning. Is that an accurate reflection of your judicial philosophy? Yes, Barrett replied. I believe constitutional provisions should be understood as they were when adopted. Excellent, Crockett said evenly. Then perhaps you can clarify something. In your opinion in Students for Fair Admissions versus Harvard, you argue that race-conscious admissions policies violate the Equal Protection Clause of the 14th Amendment, stating that its original meaning does not allow such policies. Barrett straightened slightly. That's correct. The 14th Amendment was intended to end government discrimination on the basis of race, not to permit it. Then came Barrett's calculated move to reassert control. Congresswoman Crockett, you've spoken often about constitutional interpretation despite having limited judicial experience. Perhaps you could explain the originalist view of the 14th Amendment for the committee, Barrett said, her tone carrying a measured challenge. Several Republicans smirked, anticipating Crockett's discomfort. The question was clearly designed to underscore what Barrett saw as a lack of depth. Crockett didn't pause. She smiled. I'd be happy to, Justice Barrett. In fact, I've done extensive research on the original meaning of the 14th Amendment, she replied, opening her portfolio. As any originalist would agree, the starting point is to examine what the amendment's framers themselves understood it to mean. The same Congress that drafted the 14th Amendment also passed the Freedmen's Bureau Acts of 1865 and 1866, which provided education and land specifically for formerly enslaved people. These race-conscious policies were enacted in the same period as the 14th Amendment. Barrett's expression shifted slightly as Crockett went on. Senator Charles Sumner, one of the amendment's chief architects, stated clearly that it allowed proactive legislation to secure equal rights for formerly enslaved individuals. The congressional record from the 39th Congress contains over 30 similar statements from its framers. She produced another document. Additionally, I reviewed every race-conscious federal program passed between 1865 and 1880, when the Reconstruction Amendments were written, ratified, and first applied. There were 17 such programs, and none were viewed as unconstitutional by those who drafted the amendments. Barrett attempted to steer the conversation back. Congresswoman, the specific policies of the Reconstruction Congress don't necessarily define the public's understanding of the constitutional text. The Equal Protection Clause speaks for itself. On that point, Justice Barrett, Crockett replied smoothly, producing another document. I've compiled newspaper coverage of the 14th Amendment from 1866 to 1868. The Chicago Tribune, New York Times, and even the conservative National Intelligencer all described it as permitting special protections for formerly enslaved people. Not one major paper at the time claimed it prohibited race-conscious remedial measures. The hearing room fell notably quiet. Journalists typed rapidly. Several committee members leaned forward, clearly struck by the depth of Crockett's historical record. Barrett adjusted her tone. These are interesting historical details, Congresswoman, but the text is central to originalist analysis. The 14th Amendment states that no state shall deny any person equal protection of the laws. It does not distinguish between benign and harmful discrimination. Crockett nodded respectfully before responding. On textual grounds, Justice Barrett, the original public meaning of equal protection of the laws must be read in its historical context. The phrase originated in the antebellum era, when abolitionists used it to argue for substantive equality, not merely identical legal treatment. She presented a bound volume. I've documented every recorded use of the phrase from 1830 to 1868. In each case, it referred to equality of condition, not just procedural fairness. For example, Charles Sumner's 1849 argument in Roberts v. City of Boston used equal protection to support race-conscious measures for previously oppressed groups. Barrett's composure appeared to waver as Crockett continued her steady line of questioning. Justice Barrett, your own mentor, Justice Scalia, stressed that originalism requires a full understanding of historical context when interpreting constitutional provisions. Yet your Harvard opinion contains no analysis of the race-conscious policies enacted by the very Congress that drafted the 14th Amendment. How do you reconcile that omission with originalist methodology? Barrett attempted to pivot. Congresswoman, isolated historical examples cannot override the clear textual command against racial classifications. They are far from isolated, Justice Barrett, Crockett countered, producing another document. This is the most comprehensive review to date of the 14th Amendment's original public meaning regarding race-conscious remedies. It contains over 200 sources, statements from the framers, legal commentaries, newspaper accounts, and federal and state policies from 1865 to 1880. The evidence overwhelmingly shows that the amendment originally permitted race-conscious measures to address historic discrimination. The room was silent. Several Republicans shifted uneasily, while Democrats followed intently as Crockett challenged one of the nation's most respected jurists using her own preferred methodology. Barrett's voice had lost some of its earlier edge. Congresswoman, I appreciate your research, but the court must balance multiple considerations in constitutional interpretation, including consistency across contexts. Exactly my point, Justice Barrett, Crockett replied. In your Bruin opinion on the Second Amendment, you relied extensively on founding-era regulations. Yet in your Harvard opinion, you dismissed Reconstruction-era evidence as irrelevant. Doesn't this inconsistent application of originalism suggest factors beyond original public meaning may influence the court's decisions? The chair glanced toward the clock, relieved Crockett's time was nearly over. One final question, if I may, Crockett said quickly. Justice Barrett, given the extensive historical evidence I presented, would you reconsider your claim that originalism clearly prohibits race-conscious remedial policies? The question lingered. Barrett, known for her precise legal reasoning and comfort in high-stake debates, now faced a direct methodological challenge. Her answer would reveal whether her commitment was to originalism itself, or to outcomes shaped by other considerations. After a pause, Barrett responded with measured candor. Congresswoman Crockett, your historical research is extensive. While I don't agree with all your conclusions, I must acknowledge the historical record around the 14th Amendment is more complex than some recent opinions have reflected. A murmur spread through the room. Such a concession from a Supreme Court justice on a contentious issue was highly unusual. Journalists exchanged quick glances. Understanding the moment's weight, Barrett continued. The court's originalist methodology should indeed strive for consistency across constitutional provisions. Your point regarding the Reconstruction Congress's race-conscious policies deserves serious consideration in ongoing jurisprudential development. This rare acknowledgement from a justice known for firm convictions signaled an openness to reevaluating what had been. Randall Kennedy of Harvard Law School and Professor Melissa Murray of NYU Law School. It examines race-conscious remedies from the Reconstruction era through the Civil Rights Movement and their fit within originalist methodology. The revelation that Crockett had collaborated with two of the country's most prominent constitutional scholars, both from elite institutions typically linked to judicial nominees, prompted visible reactions. From the gallery, Justice Sonia Sotomayor gave a small nod. Legal reporters typed furiously, knowing this would dominate headlines. Barrett, maintaining composure, regarded Crockett with newfound respect. I would be interested in reviewing that analysis. Representative Crockett, rigorous historical scholarship strengthens constitutional interpretation, particularly when it challenges assumptions. Crockett nodded. That's exactly the point, Justice Barrett. Originalism, when applied with full historical rigor instead of selective citation, can lead to conclusions that don't always align neatly with modern political divides. The framers of the 14th Amendment were not theorizing from a distance. They were actively dismantling the legal and economic remnants of slavery through constitutional means. The chair moved to proceed. The gentlewoman's time has expired. If I may briefly respond. Barrett interjected, an uncommon step for a witness. The chair allowed it. Representative Crockett, while we may continue to differ on certain applications, I want to acknowledge the depth and seriousness of your constitutional analysis. Our democracy benefits when elected officials engage with these principles at this level of sophistication. I look forward to reading your work. This final statement, a Supreme Court justice publicly recognizing the scholarship of a congresswoman she had originally intended to challenge, marked a complete reversal of expectations. What began as a planned lesson had ended with mutual professional respect and a rare public concession from a sitting justice as Crockett returned to her seat. Cameras captured a moment that would dominate headlines, a freshman Congresswoman matching a Supreme Court justice on her own interpretive ground. Barrett's expression showed both professional regard and the quiet realization that her assumptions had been directly and publicly tested. The victory was not just personal for Crockett. It sent a powerful signal about who holds authority in interpreting the Constitution and whose historical insights count in those debates. In that moment, she reshaped not only her public profile but also the broader conversation about the role of elected representatives in constitutional interpretation. The aftermath of the Barrett-Crockett exchange was swift and far-reaching. As the hearing concluded, reporters surrounded Crockett in the hallway. "Congresswoman, did you expect Justice Barrett to acknowledge limits in the court's historical analysis?" asked a CNN correspondent. With characteristic directness, Crockett replied, "I came prepared for serious constitutional discussion. The American people deserve nothing less when we're debating the document that shapes our lives." Within hours, clips of the exchange went viral. #Crockett Schools Barrett and Originalist Showdown trended on Twitter. Memes contrasted Barrett's dismissive opening question with her eventual concession to Crockett scholarship. Legal blogs weighed in immediately. Scott's blog published an analysis titled "When Congress Challenges the Court, Barrett and Originalism," noting that Crockett's Reconstruction-era evidence posed a substantial challenge to the court's current 14th Amendment jurisprudence. Constitutional law professors began incorporating the exchange into classroom lectures. Within days, Harvard professor Lawrence Tribe tweeted, "Representative Crockett's masterful originalist analysis of the 14th Amendment should be required viewing in every constitutional law class. She proved that rigorous history can yield progressive conclusions." Conservative outlets initially sought to downplay the moment. Fox News suggested Crockett had blindsided Barrett with obscure historical facts. Yet even conservative legal commentators found it difficult to dismiss her argument. Former federal judge J. Michael Luttig admitted on CBS News, "Representative Crockett raised legitimate historical questions about the court's interpretation of the 14th Amendment." The most unexpected reaction came from within academia. Professor Randy Barnett of Georgetown Law wrote weeks of preparation had led to this moment. Representative Jasmine Crockett had spent countless hours with top constitutional scholars, digging deep into Reconstruction-era history, building a meticulous case that exposed inconsistencies in recent originalist court rulings. The House Judiciary Committee hearing was electric. Journalists lined the walls, cameras rolling. Lawmakers from both parties arrived early, angling for front-row seats. The wood-panel room and portraits of past legal giants gave the scene an almost cinematic weight. The witness table sat Justice Amy Coney Barrett, alone, composed, and unreadable. A glass of water untouched. Navy suit crisp, hair perfectly pulled back. She radiated calm authority. After opening statements and the usual round of questions, the chair finally recognized Representative Crockett. She approached the podium with quiet confidence, placing her portfolio down, adjusting the microphone. "Thank you, Justice Barrett, for being here," Crockett began. "I'd like to discuss your approach to constitutional interpretation, especially concerning the Reconstruction amendments." Barrett nodded, expression steady. "Before my first question," Crockett continued, "can we agree that the Constitution should be interpreted according to its original public meaning? Is that a fair description of your judicial philosophy?" "Yes," Barrett replied. "I believe constitutional provisions should be understood as they were at the time they were adopted." "Excellent," Crockett said. "Then perhaps you can clarify something." From there, Crockett dissected Barrett's opinion in Students for Fair Admissions versus Harvard, pressing on why the Equal Protection Clause, written in the shadow of the Civil War, should be read as forbidding all race-conscious policies when historical evidence from the era showed otherwise. Barrett defended her reasoning, but Crockett's methodical historical record made the room lean in. The Wall Street Journal later wrote, "Regardless of whether one agrees with her conclusions, Representative Crockett's methodology was solid. She focused on historical public meaning and highlighted inconsistencies in the court's application of originalist principles. This is how originalist debate should proceed." For black women in the legal profession, the moment resonated deeply. Social media lit up with clips of Crockett holding her ground against a Supreme Court justice. Law schools reported a surge of interest from young black women inspired by her poise and preparation. Even Barrett seemed affected. 2 weeks later, during a speech at Notre Dame Law School, she remarked, "Originalism requires constant reassessment of historical understanding. The Reconstruction era poses unique interpretive challenges requiring rigorous historical investigation." Observers notice Barrett's language had shifted, slightly, but meaningfully, toward a more nuanced historical lens. 3 months later, in a case on race-conscious federal contracting, Barrett's questions during oral arguments sounded strikingly like Crockett's hearing analysis. And when the decision was released, her concurring opinion, while still conservative, engaged with Reconstruction-era history in a depth she hadn't shown before. The Harvard Law Review published a commentary titled Barrett After Crockett, Evolving Originalism on the Supreme Court. For Crockett, the exchange was career-defining. Invitations poured in, commencement speeches, guest lectures, and the American Constitution Society naming her Constitutional Voice of the Year. Even critics like Representative Jim Jordan conceded. "I disagree with almost everything she says, but Crockett knows her constitutional history. If you're going to debate her, you better come prepared." 6 months later, Crockett and Barrett shared a stage at Georgetown Law for a symposium on originalism and the Reconstruction Amendments. Cameras captured them side by side, a moment symbolic of what happens when rigorous preparation meets open intellectual engagement. Barrett summed it up perfectly. Historical evidence matters. Methodological consistency matters. And genuine engagement with history enriches constitutional interpretation, even when we reach different conclusions. What began as a tense public challenge had evolved into a case study in respectful, substantive debate, now taught in law schools and cited in political science courses. And for everyday Americans, the lesson was clear. The Constitution isn't just for judges and lawyers. It belongs to anyone willing to learn its history and engage with its meaning. If you found this story inspiring about how one representative's preparation reshaped the conversation at the highest levels, hit the like button, subscribe, and share your thought below. Which moment from this exchange impressed you most?